Hello, my name is Robert Fleming. I'm an author, a longtime elder law practitioner, and I want to talk to you about the durable power of attorney. A power of attorney is one of the most important and powerful documents that you can create. It is also one of the most dangerous. Because of the potential for abuse and exploitation, you need to give the process a lot of thought and plan carefully. Do your own research. To avoid becoming a victim, you must be an educated consumer. You must understand your options, and you must know your rights. A power of attorney could be a useful tool in your time of need. If it is granted to the wrong person, it could actually be used to your detriment. Your agent will have great control over you and many of your rights and powers. To protect you, the law forbids your agent from acting in a way that is against your best interests. While the legal protections do help deter exploitation, abuses can and do occur. To ensure that you are as protected as possible, be selective in choosing your agent as well as deciding what authority to give to him or her. A durable power of attorney is designed to provide power and authority to another person to make your decisions even after you are incapacitated or lack the capacity to make your own decisions. Generally speaking, an agent can be granted most rights if they are included in the document. It is helpful if the power of attorney is clear, detailed, and explicit about what rights are being given so that you maintain as much control over the grant of authority as possible. Give the person you have appointed as agent a copy of the document so that they know they have responsibilities, and also so they can prove their position to banks, brokers, and others they will need to deal with. For certain large transactions, like buying or selling property or title transfers, the agent will have to present the power of attorney document before the business is conducted. For smaller day-to-day transactions like signing checks, the same level of documentation might not need to be provided. Not every right can be delegated by a power of attorney. An agent does not have the authority to amend or revoke a will, to contract a marriage, or to vote on your behalf. Depending on the document and state law, however, it may be possible for your agent to change insurance beneficiaries, alter a trust, or make substantial gifts of your property. The power of attorney could provide the agent the explicit authority to make gifts on your behalf. If you wish to grant this power, be clear that the document spells it out, how you want gifts to be given, to whom, and for what occasion. You probably will want to give your agent access to bank accounts. If you ask for help with this goal at your bank, you will likely be offered a joint account signature card. This is not the same thing as a power of attorney. The joint account owner has the right and power to use the money for their own benefit, and upon your death, the joint tenant actually owns the entire account. You may even expose your bank accounts to the other signer's creditors, tax liability, child support, spousal maintenance claims. Far better to leave your bank accounts in your own name, give your agent a power of attorney, and if you want the accounts to flow to your agent or to someone else automatically at your death, designate a POD, payable on death beneficiary. If you ever want to revoke or terminate your power of attorney, you should do so in writing and have it notarized and even perhaps witnessed. Once the termination or revocation is written and notarized, you need to give a copy to your now former agent and also to any financial, medical, or other institutions that received a copy of the original power. You can revoke or terminate a power of attorney as long as you have capacity to do so. Your rights and powers are important and must be protected. The power of attorney is meant to be a helpful document, not a license to steal. In order to help prevent exploitation, be careful to choose an agent you trust completely and without qualification. Discuss with your agent the power and how you expect it will be used. If you consider the alternatives carefully and make your desires known now, then you will have more control over your own life, even if you lose the capacity to handle financial affairs directly. Considering the importance and complexity of these documents, you may wish to consult with a local attorney familiar with elder law, estate planning, and powers of attorney. Thank you for this opportunity to speak with you on behalf of the Elder Consumer Protection Program and Stetson University College of Law.